Hi, everybody. Thank you very much for coming along to this presentation. The real idea of today is to give startups and investors in startups a quick overview of the Russian sanction rules and how they impact on companies raising investment. To be honest, what's prompted this is we've done a number of VC rounds in the last month or so where this issue has come up. And I'll be honest, it's caused a lot of confusion, both on the investor side and also on the company side. And so we thought it'd be useful to just briefly explain how this works. It is quite a technical legal area. And so in order to help, what I've done as we go through the slides is put the relevant law on one side and then the actual content of the slides on the other. Because it's quite a complex area of law, this is going to be really short and sweet, so probably no more than half an hour, and I'll take any questions at the end. Before we start though, a quick bit about us. So Buckhurst is the only law firm in the market who work exclusively with startups. We have been around 10 years or so now, and literally working with startups is all that we do. London being London, our client base is quite heavily tech, so probably about 70% of our clients are tech, roughly half of those are fintech, and the balance of our clients is a weird and wonderful mix of other startups. We have quite a big sort of hospitality group, and as I say, some weird and wonderful other bits and bobs. In terms of the investment piece, our sweet spot is sort of earlier stage investment rounds. So Series A, Series B is the area that we most enjoy, but we do an awful lot of earlier stage work as well. So literally all the way from sort of first SEIS round through to late stage VC. Cool. So things we're going to cover then. I'm going to start off giving just a brief background to where the Russian sanction regime has come from. We'll have a quick look at the legislation, and then we'll run through a case study, which is essentially, a UK company raising investment, but with various different shareholders who have Russian connections. We'll also very quickly touch on the impact of the sanctions regime on secondary transactions. So this is where existing shareholders are selling their shares, perhaps to a VC coming in or to somebody else. And we'll finish with some practical stuff. So what do you do if you fall foul of the regulations? What can you actually do to allow transactions to continue to happen? And then finally, how do you protect yourself from getting stuck with this stuff? And as we'll talk about, that really comes down to doing AML checks properly in respect of all transactions going forwards. So, as many of you will know, the origin of the sanctions regime for Russia came from Russia's invasion and annexation of Crimea in 2014. And as a result of that, the EU passed a series of counter regulations which imposed sanctions primarily on specific persons. So it was basically some oligarchs and then people who were specifically involved in military activity in Crimea. So, generals, those sorts of people, and some financiers who had or were seen to have sort of funded the invasion. Now, obviously, back in 2014, we were a member of the European Union, and therefore the council regulations applied to us in the UK in just the same way as they applied to everybody else. In January 2020, as you will all know, the UK left the European Union. And what that meant was that we passed some specific regulations that effectively passported the council regulations that were already in existence in the EU into UK law. So those were the Russian sanctions EU exit regulations. As I say, they just replicated the existing position pre-Brexit. 24th of February this year, Russia invaded Ukraine. And as a result of that, both the UK government and the European Union and a number of other governments imposed a new sanctions regime on Russia. They were done in the UK through amendment regulations to those original 2020 regulations. It's worth just thinking about what the government has done here. So historically, when we've sanctioned countries, it's tended to really look at a couple of things. So specific individuals have been sanctioned, and they tend to be people who are seen to be doing bad things. So primarily politicians and sort of military people. So that's been the sort of first thing we've tended to do. The second thing we tend to do is sanction banks. So if you look at the Iranian sanctions, which have been around for a very long time now, what you have with Iran is not all, but pretty much all Iranian banks are subject to sanctions. So you can't move money through them. And obviously that impacts on the ability of the Iranian economy to operate and to interact with the rest of the world. So that's sort of the second thing, really sort of attacking banks. And then the third thing that we have traditionally done is to limit the flow of goods and services, primarily that relate to military stuff. So again, if you think Iran, it is illegal to provide equipment that can be used to create nuclear reactors and those sorts of things because of the Iranian sanctions. What's happened here with the latest batch of Russian sanctions is that UK government and a load of other governments have gone a hell of a lot further. And what they've effectively started doing is sanctioning, to some extent, normal people in Russia. So not only have we got the original batch of sanctions that we've traditionally done, you've now got restrictions in place that effectively stop, in many circumstances, stop people in Russia doing certain things. And I would say that's a pretty significant change. And as we'll see, it impacts potentially on investment around stuff. So in respect of the amendment regulations, which are the sanctions regulations we're primarily thinking about here, the government have got very excited and have created a whole bunch of different amendments. The starting point was the one in the middle, so the Russian Sanctions EU Exit Amendment Regulations 2022. That basically gave the Secretary of State enhanced powers to sanction individuals. That started out sanctioning oligarchs, and you've probably seen the case of Roman Abramovich, who's now subject to sanctions. The government have now extended it really quite broadly. So they've sanctioned a number of MPs, Russian MPs. They've sanctioned, military people to generals who are active in Ukraine. A whole bunch of specific sanctions are out there. So that's done by the original ones. Number two is what we're most interested in today. So number two relates to transferable securities and money market instruments. For completeness, number three is basically goods and services relating to military. Number four is ships and shipping. Number five is specific banks. Number six is aviation and space and shipping equipment. So effectively, things needed to maintain planes and ships and space rockets. And number seven is a facilitative piece of regulation which allows the government to not only sanction specific named individuals, but sanction specific classes of people. So, for example, they've sanctioned members of the Russian parliament who are broadly in sort of Putin's party, if you like. So that's the whole group of them. As I say, we're focused really today on number two, which is sanctions specifically relating to transferable securities and money market instruments. I thought the easiest way to help you understand the way the sanctions regime works is to just do a little case study. Now, as a complete aside, and perhaps to bring a small amount of levity to a topic that is not particularly amusing, I have two dogs. One is called Toby, he's a Jack Russell. The other is Boris, and he's a Labrador. For these purposes, they have come together, they have got a company, and we've called it Puptito Limited. So there you go, that explains the rather bizarre company name. So in our case study, Puptito Limited is raising investment from UK and EU venture capital firms. So it's doing a VC round. It's got some Russian connections within its shareholder base. So Toby, who's one of the founders and is a UK national, so he's a Brit, is currently living in Russia and has done for the past 3 years. He owns 40% of the shares in the company. So that's Toby. Boris is a Russian national, so he's got a Russian passport. He very recently moved his entire life and family from Russia to Latvia. And he has a 20% shareholding in the company. Now, just in respect to Boris, this actually relates to very, very similar facts to a deal we just worked on, where actually a couple of the founders of a UK company who had been living in Russia for lots of different reasons, when Russia invaded Ukraine, they left and they moved their entire family to Europe. They, moved kids out of school, put them in schools in a European country, rented property, sorted all their visa stuff out. So literally moved their life. So to some extent, this is sort of originated from a real world example. Now, for completeness, so that we're not making this too complicated, Perpetito operates a tech platform. It has no relation to sanctioned industry. So it's not caught by any of the goods and services sanctions that are covered by other regulations. And again, neither Toby nor Boris are individually sanctioned. So they're not oligarchs. They haven't been involved in the war. So the only thing really that we're thinking about here is the share capital. So the law that is relevant here, as I said, is the number 2 regulations. And I've copied the text here for you so that if you're so inclined, you can try and make head and tail of it. But the key point really to understand is this. So what they're saying is a person must not directly or indirectly deal with a transferable security or money market instrument if that security or money market instrument is issued on or after the 1st of March this year by a person connected with Russia, a person other than an individual, so in other words, probably a company which is owned by a person connected with Russia, or a company acting on behalf of or at the direction of a person connected with Russia. So to summarize again, you can't deal with transferable securities or money market instruments issued after the 1st of March by a person connected with Russia or a company owned by a person connected with Russia or controlled by a person connected with Russia. So what does that mean in practice? The first bit is, what does transferable security mean? So what are we talking about? As I say, left-hand side of the page, you've got the relevant law, and I've highlighted the bits that are relevant to help make it more straightforward to track. So transferable security, money market instruments. A money market instrument is not really relevant to our case study, but for completeness, it's basically a class of instrument normally dealt with on the money markets, so treasury bills, certificates of deposit, those sorts of things. What we are interested in is transferable securities. And transferable securities are defined by the FCA in their handbook as classes of securities negotiable on capital markets, such as shares in companies or things that act and feel like shares. So if we are issuing shares in Perpetito to VCs, we are issuing transferable securities. We fall under the first bit of the sanctions regs. The next thing that we need to think about is whether the shareholders, Toby and Boris, are connected with Russia. And as you can see on the left-hand side, there's a couple of limbs to this. The first one is a question as to whether they are ordinarily resident in Russia. So what does that mean? Helpfully, the sanctions regulations don't tell us. So they don't actually give us a definition of ordinarily resident. Of course, it would be super helpful if they did. They don't. That has caused quite a lot of questions from a number of different law firms about what on earth this really means. The latest guidance from the government on this, and the guidance that is most relevant to it, comes in some Home Office guidance issued as a result of a court case in 1983, so not exactly current. And what it found is that a person is deemed to be ordinarily resident where 3 criteria are established. Number 1, he's voluntarily adopted the country that he's gone to as his place of residence. He's done it for settled purposes, and he's done it as part of the regular order of his life for the time being. So settled purposes is essentially saying that the person in question has decided to move to that country, to live there, to be there for the time being. Now, interestingly, settled purposes is not necessarily a permanent thing. You do not have to demonstrate that you've moved to the country you've moved to and you intend to be there until you die. It is permitted to be for a limited period. So there's no hard and fast rules here, but what the rules are really looking at is indicators of things that suggest that you have moved and you intend to stay for the time being. So things like education, you've enrolled in a degree, you've got a business interest in the company, you've got a job in the company, in the country, you're perhaps in the country for health purposes, or because your family are ill, or because you want to spend more time with your granny who lives there. So all of these things are potentially indicative of a settled purpose. Now, really importantly, ordinary residence, what is relevant is not the subjective intention of the individual. So it's not a question of what we think the individual may be intending. We have to look at the evidence that has been provided or that is available to figure out what their objective intention is. And as we'll talk about at the end, what this basically means is when you're trying to figure out, as in the case of Boris, where someone is ordinarily resident when they very recently left Russia, you need to be looking at the evidence that they can provide to come to your conclusion. So things that might be relevant in Boris's case, it's not just him. He hasn't skipped the country and left his family there. He's moved his entire family to Latvia. As I said, he's enrolled his family in schools. He's rented a property. He may have registered for taxation, for council tax. Those sorts of things suggest, actually quite strongly, an intention to be settled in Latvia. The next sort of thing that relates to connected with Russia is whether somebody is located in Russia. Now, the good news is that's pretty straightforward. If somebody is physically present in Russia, they are located in Russia. We don't really need to sort of look further at guidance to that. And then the final touch point is whether somebody is domiciled in Russia. So again, there's no statutory definition of domicile in the regulations, and actually, again, more broadly, there's no sort of statutory definition in broader legislation. An important thing to remember here is that somebody's domicile can change, and it can change because it has to by necessity, or it can change by choice. If you decide to move country by your own free will because you want to, your domicile changes immediately that you land in the new country. So if we think about Boris, he left Russia, he took his family, he moved out of Russia, presumably he didn't want to be there any longer, and he went to Latvia. His domicile changed when the plane landed and he got through border control. So he is now domiciled in Latvia, not Russia. So that domicile point is, in practice, relatively easy to demonstrate that you've moved country and you're no longer domiciled in Russia. So what do these rules mean for our case study? So going back to our fact pattern, so Toby, he's a Brit with a British passport and he's living in Russia. He is ordinarily resident in Russia. I think it's highly unlikely there's any other way of looking at it. He's lawfully residing there. He's been settled in Russia for 3 years, and physically he's still present. So really, no question, he is ordinarily resident in Russia. Boris, by contrast, so you'll remember that Boris was a Russian national with a Russian passport who had recently moved to Latvia. And that could, by the way, be last week. He could have moved last week to Latvia. So in that circumstance, it's very likely he's ordinarily resident now in Latvia. Why? He settled in Latvia with his family, suggesting a permanent intention to remain in Latvia. He's physically present there. That's where he is. All of these things suggest that he's now ordinarily resident in Latvia and not in Russia. You'll note that we haven't talked about the nationality of Toby and Boris as as being relevant to ordinary residents. The reason is essentially it isn't. You can see Toby, ordinarily resident in Russia, despite not having a Russian passport and being a Brit. By contrast, Boris, a Russian national, ordinarily resident in Latvia. The nationality is really not that relevant to this. And I think it's an important point. A couple of our clients have said to us, we're not going to take investment from people with Russian passports. It's too risky, it's a problem. That really isn't the way to look at it. The fact somebody has a Russian passport is pretty much irrelevant. What we are worrying about is whether they are residents in Russia or not, and obviously whether they're on sanctions list, but primarily whether they're resident. So again, the fact somebody's got a Russian passport is really not that relevant to this at all. So we've identified that Toby is resident in Russia and Boris is resident in Latvia, so not in Russia. In our case study, PopTito is issuing shares to investors, and we need therefore to understand whether PopTito is owned by a person connected with Russia. Now, the meaning of owned by is actually set out in the OFSI guidance. So the Office of Financial Sanction Implementation is a department in the Treasury. As an aside, you are able to contact OFSI for guidance on the sanction rules. If you do, optimistically 2 weeks later, but potentially quite a lot longer, they'll send you a very unhelpful email back telling you that they can't give any advice on it and you need to go and get your own legal advice. So it's pretty much a waste of time to contact them, to be frank. Unhelpful, but true. Anyway, their guidance sets out what owned by means. And really, it's looking at control. So the guidance says an entity is owned or controlled directly or indirectly by another person in any of the following circumstances. And the one that's relevant to us is that the person holds directly or indirectly more than 50% of the shares or voting rights in the entity. Now, just by way of interest, this is very, very similar to the control definition that you find in the Companies Act and also the control definition that you find in tax legislation. So there's a degree of sort of logic to this. But the crucial point is that the individual must have 50% or more of the shares or voting rights. Now, in our example, neither Toby nor Boris individually have in excess of 50%. So Toby had 40%, Boris had 20%. Neither of them breached that 50% threshold. Now, you might be thinking to yourself, okay, but both Toby and Boris are founders of this business. And presumably as founders, they work together. They take decisions collectively. Therefore, it wouldn't be silly to think to ourselves that they may actually be connected persons and that therefore they are essentially aggregated. I have completely gone the wrong way. And that therefore they may be aggregated for the purposes of this test. That isn't the case. So again, the OFSI guidance has a section on joint control, and it's very, very clear that just because two people are, because they work together, just because they happen to be founders, does not mean that they're connected for these purposes. And so it doesn't mean that you have to aggregate their shareholdings together to look at the 50% threshold. That said, there is a final limb, which you can see on the left-hand side, which is that you must ensure, or you cannot transact in a transferable security that is issued on or after the 1st of March 2022 by a person, a company, acting on behalf of or at the direction of a person ordinarily resident in Russia. Now, again, the OFSI guidance is pretty helpful here. It gives some quite useful, non-exhaustive examples of situations that would suggest that somebody is acting on the direction of another person. So the situations would be, imagine that, for example, Toby has the right to appoint or remove a majority of the directors. That would mean that he would have control of the business, and so PopTito will be acting on his behalf or at his direction. Other things that are potentially relevant. So if he can control through a shareholders agreement a majority of the voting rights of PopTito, then again, PopTito is acting in his direction. If he can exercise a dominant influence, which effectively means that even though he may not have 50% of the voting rights, he can procure that people support him, and therefore that him and them together exercise more than 50% of the voting rights. And then the final one, and the one that potentially could be trickier on occasion, is if, for example, Toby has control of the bank accounts, that means that he has control of the way that the company spends money. that can actually give him, can mean that Partito is acting at his direction. So this acting at the direction of is really designed, in essence, to try to stop people creating artificial structures that get outside of the strict control rules, but still enable them from Russia to control an entity. So you do have to be careful about this particular limb and make sure that there's nothing in place that potentially causes you a problem. On a transaction we looked at recently, actually nothing to do with sanctions at all, but there were provisions in the shareholders agreement that effectively gave one of the investors outright control of the business in certain circumstances. These things are not entirely unseen and not entirely unusual. So when you're assessing whether this particular limb of the regulations applies, you should be looking at the shareholders agreement and potentially the articles, just to make sure that there isn't somebody unexpected who does actually have or fall within this limb and potentially have outright control. So that's, if you like, the position when raising investment. So what are we thinking about in summary there? We're thinking about who are the shareholders of the company that is looking to do an investment round. Are any of them ordinarily residents in Russia? If they are they in control of the company? So do they have more than 50% of the voting rights or shares, or can they otherwise direct the company to act at their behest? So those are the things that we're thinking about. Now, as part of investment rounds, you will sometimes do secondary transactions. So you'll have a situation perhaps where some of the founders will sell some of their existing shares to VCs as part of the round. Those secondary transactions are generally going to be absolutely fine, so long as the company whose shares are being sold is not owned by somebody ordinarily resident in Russia. So if we just go to our original example of Partito, let's imagine that Toby intends to sell some of his shares to investors in the round. And so what he's doing is he's transferring existing shares, so shares he currently holds, and he's receiving cash into his personal bank account. That transaction isn't prohibited. Why isn't it prohibited? It's not prohibited because Rule 16 of the regulations, so the rule that we've just been looking at, imposes restrictions on the issuer of the shares, not on the holder. So we're looking at whether Partito itself is ordinarily resident in Russia, not whether the seller of the shares is. And as a result, even if you imagine that Toby, let us imagine that he is actually ordinarily resident in Russia, isn't he? So he's ordinarily resident in Russia. Even though that's the case, he can still sell his shares and the investors can still buy them, because what is relevant is the residency of the company Partito. So what do you do if you've got a prohibited transaction? The first thing you need to do is get expert advice. If you get this stuff wrong, you can go to prison. It's a very serious criminal offence to breach the sanction rules. So if there's any question that you may have a situation that is in a grey area, or you may have a transaction that is subject to sanctions, you must get advice, and you must get it sooner rather than later. Once you've got advice and you've understood the legal position that you're in, you do have a couple of options if you are, or if you wish to go ahead with a prohibited transaction. The first one is you can contact OFSI and get a clearance, if you like, to proceed with the transaction. Primarily, they will give that where, putting it in layman's terms, the transaction is caught by the regulations, but is not a transaction that they're particularly bothered about. And so, perhaps as an example, imagine that that Toby didn't have 40% of the shares; he actually had 51% of the shares. Suddenly, then Partito would be sanctioned. My instinct is OFSI wouldn't be particularly bothered about that, because the company itself is not doing anything that relates to military or sort of critical industries. The only reason that it's subject to sanctions is simply because Toby's living in Russia. My instinct is they probably would allow that transaction to happen, but with a clearance. For the avoidance of doubt, you can't just make assumptions about this. You need to wait for the clearance in order to be compliant with the law. The second approach is that you could create a situation where the shareholder who has control and is ordinarily resident in Russia cedes that control in some way. Depending on the fact pattern, there are different ways of doing that. It may be that the shareholder can simply resign as a director, and that breaks the control link. It may be that the company can amend the rights attaching to shares to create a majority of voting rights in a class of share that the controlling shareholder doesn't hold, or it may be that they can otherwise, play with the voting rights or play with the control, perhaps even through contracts. So there are ways of removing control from a shareholder who is causing us an issue in this case. And then the final thing that you can do is potentially create dilution. Now, you have to be very, very careful with doing this because the company itself is sanctioned, nobody can receive newly issued shares. And so you can't simply issue further shares to people and dilute a controlling shareholder, because that in itself would breach the sanction rules. What you can do potentially is play with the share classes and potentially play with the voting rights attached to shares to actually dilute out the controlling shareholder. But I would just say, again, you shouldn't be doing any of these things without specialist advice. Get specialist advice before you do this, because anything you do with the best of intentions, if you get it wrong, you commit very serious criminal offences. And then final point here, anything you're doing must be a long-term arrangement. You cannot get around these rules, for example, by getting a majority shareholder to go on holiday for 2 weeks to Europe. So leave Russia, go on holiday to France for 2 weeks, do the transaction and then fly back. That will not work. It's illegal. You must be taking any steps that are designed to solve the problem on a long-term basis. And therefore, by extension, they must remain in place after the transaction has happened. Final thing before we take questions, what do you need to do if you are an investor, you're proposing to make an investment into a startup, or if you are if you're a startup yourself looking to raise a round? It really comes down to understanding the residency and where people are living of your existing shareholders, the existing shareholders in a company, and any investors. So what should be happening really now is that if we look at it perhaps first from the company side, the company should be running updated anti-money laundering checks on all investors that it's taking money from and all major shareholders. Obviously, companies should already, and their lawyers as well, should already be doing AML checks on shareholders. I would strongly suggest that you update them all and that you use electronic software that can run searches on databases to see where people are showing up with addresses. So, for example, we as a firm use, amongst other things, software called Onfido, O-N-F-I-D-O. What that does, it's relatively easy to use. It sends an email link out to the shareholder. They upload their passport, they pop in their address, and then it runs a search across a whole bunch of databases. Obviously sanctions databases, but also local national databases that will track people's addresses. Now, if somebody is living in Russia, or they have a Russian connection, or they have had a Russian connection, it will spew that out, and it will give us a warning that there's a Russian connection there. Obviously, at that point, we can ask the questions and find out whether that's still a connection and what the sort of the Russian piece might be. Even if you're running electronic checks, I would still suggest that you ask outright investors and frankly shareholders to confirm where they're resident. It's a sensible thing to be doing because systems and softwares don't always get this stuff right. At least if you're asking the question, then you've got a good chance of getting a sort of second verification of what the software is spewing out. When you've done all this, you clearly need to review the results of the money laundering software, have a look and check for any indication of Russian residency. If you've got Russian residents or you've got Russian connections that are problematic, analyze the sanction rules to see, to see whether those Russian connections are an issue. Are they controlling shareholders? Are they still ordinarily residents in Russia? And if they are, then you need to figure out what to do about it. Now, as you can see, in most circumstances, having people resident in Russia will not cause you a problem. Really, probably, we're only, in practical terms, in most cases, worried about people with more than 50%. But you need to know where the risks might be. And final point, at the risk of laboring it too much, please get expert advice if there's any touch points that go near a problem. The punishment for getting this stuff wrong is imprisonment and some very, very nasty fines. This is really, really serious stuff. Not understanding it, not being aware of it, being ignorant of it is not an excuse. And so it's really important that you get the right advice at the right time. That's all we're going to talk about on this. I realize it's lunchtime. We want to keep it relatively short and sweet. If you'd like any further information, by all means, drop us an email. My email's not on there, but it's the easiest one to get hold of me is office@buckwheats.com. You can also sign up to our other events and get insights and stuff like that on our website. If anybody has any questions, I'm very happy to take any. And I think, let me just have a quick look. Yes, if anybody does have any questions, by all means, feel free to unmute and I can answer them.
Or if people have questions, they can email you directly at office@buckwheats.com, and then you can start the discussion there.
Indeed. Perfect. Okay, well, excellent. Well, thank you all very much for coming. I hope that was useful. Our marketing team will pop out the slides to you separately by email. And as I say, if you've got any further questions, then feel free to send us an email and we can help you directly.